here to speak on a subject that has been rankling me greatly for the past several months. And I'm sure many of you too. That of the accountability of judges. The immediate trigger for my selecting this subject was, of course, the allegations made by a former employee of the Supreme Court of India against the present Chief Justice of India and the events that followed. Over the past few months, several people have expressed concerns about how the judiciary must deal with such cases and the accountability mechanisms that exist to monitor the judiciary in their actions. The issue still remains unanswered, and the incidents that took place especially reveal the many weaknesses in the in-house mechanism that is employed for resolving such disputes. Without passing any judgment on the truth or falsity of the allegations, I must admit that there are certain stark facts that stand out which demand consideration. A permanent employee of the Supreme Court was removed from her post on flimsy allegation of her having taken half-day casual leave and protesting against her change of sitting arrangement. Her relative was dismissed from the same service soon thereafter. She made allegations of sexual harassment against the Chief Justice of India, in response to which there was an unusual hearing that took place on a Saturday without a petition having been moved in what was termed on the Supreme Court board as a matter of great public importance touching upon the independence of the judiciary. The person holding the highest judicial office in India sat as a judge in his own house. 3 judges attended the hearing, but the order that was emerged surprisingly signed only by 2 out of 3, with the Chief Justice choosing to abstain. A few days later, the Registrar General of Supreme Court issued a public statement saying that the complaint was false. Conspiracy rumors began at around the same time. A retired judge was appointed to examine the conspiracy allegations, but nothing has been heard of it so far. The Attorney General initially advised the Chief Justice that there should be an external committee. He suggested names of some retired women Supreme Court judges. And this recommendation was later seconded by Justice Chandrachud, which was a sitting judge of the Supreme Court. Instead of following this advice, a committee of judges was set up to look into the matter, with the judges being selected by the Chief Justice himself. The process of inquiry was also questionable. The complainant was not allowed to be represented by a lawyer or an ex-friend. The in-house process was not explained to the complainant despite her specific request for the same. A copy of her own evidence was not given to her. It was finally given to her after she withdrew from the case. And as you know, that she withdrew the complaint. She withdrew from the case. An order was eventually passed, but it was given only to the accused and not made available to the complainant. The entire process was shrouded in secrecy in the name of the protection of judicial independence. All these demands a relook at the accountability systems for judges in India and throws up many questions. We need to have a robust mechanism so that future incidents are tackled differently and in a better way. Keeping all this in mind, I have divided my speech into 3 sections. Firstly, I would like to revisit the tensions between the concepts of judicial independence and accountability. Secondly, I will broadly discuss the existing means used in India for judging judges. which are limited and few and far between. And finally, I will discuss what I believe needs to change for the better and attempt to put forward a roadmap for how I see this change coming about. Specifically, I see one, the scope for a new law on judicial accountability. Two, a new and more detailed code of conduct guiding judicial behavior. And three, a streamlined process for regular performance evaluation of judges of higher court. There is no procedure by which there is an evaluation of the judges working either in the high courts or the Supreme Court. The principles of judicial independence and accountability are sometimes regarded as fundamentally opposed to one another and constantly in tension. Judicial independence is an essential pillar of liberty and the rule of law. The classic defense of judicial independence, usually put forward by judges themselves, rests primarily on two arguments. Firstly, this independence is a value and an end in itself. And secondly, that any means of accountability directly impinges upon and damages judicial independence. I will give an example. While hearing the matter pertaining to the applicability of the Right to Information Act to the office, he seems to have felt that transparency impinged upon the judicial independence somehow. It was all the more surprising because the right to information as a fundamental right is developed by the Supreme Court itself. But as the adage goes, sunshine is the best disinfectant. And you will agree with me that transparency is essential to the good health of judiciary. However, ladies and gentlemen, judicial accountability is far more complex than being merely a foil for or counter to judicial independence. I believe that such an attitude comes from a mistaken understanding of the concepts and their purposes in the first place. The purpose of judicial independence, either of the judiciary as an institution or a judge individually, is never an end in itself. Its purpose is always to secure judicial impartiality. If a judiciary cannot administer the law fearlessly, then nothing else is of any consequence. Impartiality is a central and necessary feature of judicial independence. The true goal thus is judicial impartiality, neutrality. And I'm sure nobody would disagree with me on that. In other words, the actual challenge is to grant as much judicial independence as is necessary to have cases adjudicated impartially and neutrally. Maintaining this equilibrium between accountability and independence is a real task at hand. In fact, the means of accountability adopted in a particular country can determine the extent of judicial independence granted to the judges. Judicial independence, ladies and gentlemen, is manifest in our institutions in many ways. Historically, judges have always been exempt from liability for acts that they have performed in judicial office in good faith. Similarly, under the Indian Constitution, terms of appointment, tenure, remuneration, pension of judges are all protected. This is all part of a grand independence design. But immunity from liability does not mean that judge has the extra privilege of making mistakes or doing wrong. All these immunities are given for the express purpose of the advancement of cause of justice. Even though the fundamentals must remain the same, the notions of independence and accountability need to be revisited. And let me explain why. The judiciary as an institution that merely adjudicate upon the disputes between the parties is long gone. Today, all over the world, we have what scholars termed as a new judiciary, where the institution is like an activist venturing into areas of policy making and lawmaking, hitherto considered to be the exclusive domain of executive and legislative classes. The change has come about due to both circumstantial and deliberate design. The judiciary, for example, is more empowered today through accidents of history or deliberate legislative changes to deal with questions of human rights than it was before. This is especially true in India, with the tools of public interest litigation having taken over a great type of court. The Indian judiciary today is much more interested in and much more engaged with questions of social importance or that affect policy. In doing so, they are perhaps leading the charge of these so-called new judiciaries. It is no wonder that the Supreme Court of India is regarded by many to be the most powerful court in the world. Thus, this increased engagement with political issues also means the judiciary is much more public actor than it was ever before. Its role as a player in public matter means that it is more beholden to public control and public accountability than it ever used to be. Just as the judiciary has reinvented itself, conventional tools of accountability also need to be reinvented to respond to this changing institution. In India, conventionally, we have only what can be termed as hard accountability tools, such as impeachment and removal for the judiciary. But perhaps we need to think about softer tools for the judiciary to tackle circumstances that do not warrant impeachment, but do require some kind of disciplinary action. Soft accountability tools could include warning systems tied to regular performance evaluation or predefined codes of conduct that guide judicial behavior and how they should behave in their professional and private lives.